Hi friends, I'm Indian Political Chapter 10 discuss amendment of the Constitution. Like any other of the Constitution, in the Constitution of India also provides for the amendment in order to adjust itself to the changing conditions and needs. So, like any other of the Constitution, the Constitution of India also provides for its amendment in order to adjust itself to the changing condition and needs. However, the procedure of the procedure laid down for its amendment is the procedure laid down for its amendment is neither as easy as in Britain nor as difficult as in US. Other words, the Indian Constitution is neither flexible nor rigid, but is synthetic in both. Synthesis in both. Article 36, 368. Article 368, Part 20. Okay, the Constitution dealt with the first parliamentary and to amend the Constitution and its procedure. Okay, it states that the Parliament may, its in exercise of its constitutional power, and amend by way of addition, variation of repeal any provision of the Constitution in accordance with the procedure laid down for the purpose. With the procedure laid down for the purpose. However, the Parliament cannot amend those provisions which, from the basic structure of the Constitution, has his Constitution. This was ruled by the Supreme Court. But in the Kesavananda Bharati case, according to the procedure laid down for the purpose. However, the Parliament cannot amend those provisions which, from the basic structure, cannot amend those provisions which form the basic structure of the Constitution. Okay, the Supreme Court in the Kesavananda Bharati was 1973. Procedure for the amendment. The procedure for the amendment of the Constitution is as laid down in Article 368 as follows. An amendment of the Constitution can be initiated only by the introduction of a bill for the purpose in either House of Parliament and not in the state legislature. The introduction of a bill for the purpose in either House of Parliament and not in the state legislature. The bill cannot be introduced either in the ministry or by a private member, and does not require prior permission to the President. The bill must be passed in each House by a special majority, that is, a majority that is more than 50% of the total membership of the House, and a majority of the 2/3 of the members of the House are present and voting. Each House must pass the bill separately. In case of a disagreement between the two houses, in case of a disagreement between the two houses, there is no provision for holding a joint sitting of the two houses for the purpose of deliberation and passage of the bill. If the bill seeks to amend the federal provision of the Constitution, it must also be ratified by the legislature of half of the states by the simple majority, that is, a majority of the members of the House present and voting. After duly passed by both the House of the Parliament and ratified by the state legislature where necessary, the bill is presented to the President for assent. The President must give his assent to the bill. He can neither withhold his assent to the bill nor return to the bill for reconsideration of the Parliament. After the President's assent, the bill becomes an act that is the Constitutional Amendment Act, and the Constitutional stands amended in accordance with the terms of the Act. Types of amendment. Types of amendment. Article 368 provides for two types of amendment, that is by a special majority of Parliament and also through ratification by half of the states by simple majority. But some other articles provide for the amendment of certain provision of the Constitution by a simple majority of Parliament, that is a majority of the members of each house present and voting similar to the ordinary legislative process. Notably, these amendments are not deemed to be amendments of the Constitution for the purpose of Article 368. House present and voting similar to the ordinary legislative process. Notably, these amendments are not deemed to be amendments of the Constitution for the purpose of Article 368. Therefore, the Constitution can be amended in three ways: amendment in simple majority of the Parliament, amendment by the special majority of the Parliament, amendment by the special majority of the Parliament. Okay, and their rectification of half of the state legislature. Okay, by simple majority of the Parliament. The simple majority of Parliament is a number. Okay, in number provision in the Constitution can be amended a simple majority of the two houses of Parliament outside the scope of Article 368. These provisions include admissions of establishment of new states, formation of new states, and alteration of areas, boundaries, names of existing states, abolition of creation of legislature as council of states, second emoluments and allowance, privileges, and so on of the president, the governors, the speakers, the judge, etc. Quorum in Parliament, salaries and allowances of the members of Parliament, rules of procedure in Parliament, privileges of the Parliament, its members and its committees, use of English language in Parliament, number of puisne judge in the Supreme Court, conferment of more jurisdiction on the Supreme Court, use of official language, citizenship acquisition and termination. Okay. Use of official language, citizenship acquisition, termination, election of the Parliament and state legislature, the elimination of constituencies, Union Territory 16 5th schedule, administration of scheduled areas in scheduled tribes, scheduled 6 schedule, administration of tribal areas by special majority of Parliament. Okay, the majority of the Parliament provision in the Constitution need to be amended by the special majority of the Parliament. That is the majority. That is more than 50% of the total membership of each house, and a majority of 2/3 of the members of each house present and voting. The expression total membership means the total number of members comprising the house, irrespective of fact whether there are vacancies absent. Strictly speaking, the special majority is required only for voting of the either third reading stage of the bill, but by the way of abundant caution, the requirement of special majority has been provided for the in the rules of the House in respect of all the effective stages and the bill of the bill. The provisions which can be amended by this way include fundamental rights, directive principle of state policy, all other provisions which were not covered by the first and third categories, the special majorities of the Parliament and constant of state. Those provisions of the Constitution which are related to the fundamental structure of the polity can be amended by a special majority of the Parliament and also with the consent of half of the state legislature by a simple majority. If one or some of the or some or all the remaining states take no action on the bill, it does not matter the moment half of the states gives their consent. The formality is completed. There is no time limit within which the states should give their consent to the bill. The following provisions can be amended in this law: election of the president and its manner, extent of the executive power of the Union and the States, Supreme Court and High Courts, distribution of the legislative powers between Union and States, any of the list in the seventh schedule, representation of the States and Parliament, power of the Parliament to amend the Constitution of its procedure, Article 368, criticism of the amendment procedure. Critics have been criticized the amendment procedure of the Constitution of the following grounds: there is no provision for special body like Constitutional Convention as in USA or Constitutional Assembly for amending the Constitution. The constitutional power is vested in the Parliament and only in few cases. Okay, in the state legislature, the power to initiate the amendment of the Constitution lies in the Parliament. Hence, unlike in USA, the state legislatures cannot initiate any bill or proposed for amending the Constitution except in one case, that is passing a resolution requesting the Parliament for a creation or repletion of the legislative council of the state. Since here also the Parliament can either approve or disapprove such a resolution or may not take any action on it. Major part of the Constitution can be amended by the Parliament alone, either by special majority or by a simple majority. Only if in few cases the Constitution or the state legislature is required and that too only half of them. While in USA it is 3/4 of the states. The Constitution does not prescribe the time frame within which the state legislature should ratify or reject an amendment submitted to them. Also, it is silent on the issue of whether the state can withdraw their approval after according to the same. There is no provision for holding a joint sitting of both houses of the Parliament if there is a deadlock over the passage of a constitutional amendment bill. On the other hand, a provision of joint sitting is made on the case of an ordinary bill. The process of amendment is similar to that legislative process, except for the special majority. The constitutional amendment bill are passed by the Parliament and the same way as the ordinary bill. The provisions relating to the amendment procedure are too strict to sketchy. Hence, they leave a wide scope for taking the matters up to the judiciary. Despite these defects, it cannot be denied that the process has proved to be simple and easy and has succeeded in meeting the change needs the conditions. The procedure is not so flexible as to allow the ruling parties. It changes in according to their whims. Not is to so rigid as to be incapable of your adapting itself to be changing needs. It has rightly said the case where is strictly the good balance between flexibility and rigidity. It is in this context, President Jawaharlal Nehru said that in the Constitution, well, we want this Constitution to be as solid and permanent as we can make it. There is no permanence in the Constitution. There should be a certain flexibility. If you make any Constitution rigid and permanent, to stop the nation's growing of the living vital organic people. Similarly, Dr. B.R. Ambedkar observed that in the Constitutional Assembly that the Assembly has not only refrained from voting a seal of finality and infallibility upon the Constitution by denying the people the right to amend the Constitution as in Canada, or by making amendment of the Constitution subject to the fulfillment of extraordinary terms and conditions as in America or in Australia, but he has provided for a facile procedure for amending the Constitution. K.C. Farage has admired the variety of the amendment procedure contained in the Constitution of India. He said the variety of the amendment process is wise but rarely found. According to Gavin Austin, the amending process has proved itself one of the most reliably conceived aspects of the Constitution. Although it appears complicated, it is merely diverse. Okay, से पर नोट्स है दिया हुआ है तो देख सकते हैं, ठीक है। थैंक यू फ्रेंड्स।